Best & Krieger's webinar series titled From Code Compliance to Fighting Fire Traps, How to Deal with Dangerous Dwellings in Your City. We will get started in a few minutes. Before we begin, we have a few housekeeping items to go over. As a reminder, please note that all attendees are in listen-only mode. If you have any questions during the presentation, please use the question box in the lower right-hand corner to ask questions. If you wish to view and or print the presentation materials, they can be found on the GoToWebinar navigation panel under the Handout section. Both the webinar recording and materials will be available on the BB&K website approximately 24 hours after the presentation. Thank you, and I will now call over to our moderator, Mark Easter. Mark?
Welcome to part 2 of our 3-part webinar on dealing with dangerous and substandard buildings in your city or community. Last week we discussed viewing code enforcement as a toolbox with different tools, and I suppose that toolbox has actually several sections to it. In part 1 last week, Josh Nelson and Christy Lopez gave a presentation on administrative remedies, including notices of violations, office conferences, public nuisance hearings, citations, and permit and CUP revocations. The other 2 sections of that toolbox are criminal and civil remedies. This week we shift our discussion to the criminal courts, and we will discuss the advantages and disadvantages as well as the procedures involved in prosecuting property owners criminally for code enforcement violations. We are again joined by Christy Lopez, who works primarily out of our Irvine office. Christy focuses much of her practice on all aspects of code enforcement, and she serves as city prosecutor for multiple jurisdictions. Christy has successfully resolved hundreds of code enforcement cases, and one of the keys to her success is maintaining strong working relationships with law enforcement officers, code enforcement officers, animal control officers, and code enforcement management and directors. We're also joined by Charlene Wynder, who works out of our Ontario office. Charlene's practice focuses on both criminal and civil code enforcement, public entity defense, and pitches motions. Charlene's first experience as a prosecutor was doing an externship for the San Bernardino County District Attorney's Office. Before joining Best & Krieger, Charlene got extensive experience with another firm representing municipalities in criminal, civil, and administrative actions, as well as writs and appeals. And before I turn it over to Christy, I just want to welcome again those of you who are participating from out of state. Most of what we discussed today, criminal prosecutions, will be pertinent to prosecutions in all states, but we get to things specifically like fines and penalties. The focus of our discussion will be California state law. So with that, let me turn it over to Christy to give an overview of what we'll be discussing today.
Thanks, Mark. If I can get you to go to the next slide. So as Mark already stated, there's 3 different tools that we have to deal with code enforcement, and that includes administrative, criminal, and civil. Today we'll be focusing on those criminal remedies. So some of the things we'll be talking about today. First, we'll be looking at what considerations we take into account when deciding whether to pursue criminal prosecution as a code enforcement remedy. Next, we'll look at the advantages to criminal prosecution and how that works for local entities, as well as disadvantages to criminal prosecution, and for example, what might be some of the backlash as a result of bringing in a property owner or business owner into criminal court. We're going to compare both criminal cases and civil code cases to see how they line up, and look again at the advantages and disadvantages of these types of enforcement actions. Finally, next we'll look at how a criminal case would work, starting from the beginning of an arraignment, evidentiary issues, and all the way through trial and sentencing. Next, we'll address some recommendations for your best practices in improving your code cases should you decide to pursue criminal prosecution. And finally, if there's time, we'll open the floor for questions. Next slide. So when we take a look at whether we want to pursue criminal prosecution, one of our main considerations that we often address first is this criminal conduct or is this an illegal condition? So in other words, is this a property maintenance issue that is ongoing, or is this a single condition such as overgrown weeds? One of the reasons we look at that first is things like overgrown weeds, for example, is a condition that can be rectified through an abatement warrant, for example, or different types of remedies. And property maintenance is an ongoing obligation that a property owner may be unable to continue, and therefore keeping that property owner within the court's jurisdiction may be something that's ideal for the city. Now, criminal prosecution is something that is oftentimes considered when administrative remedies have proven to be unsuccessful. So if you've already issued your notices of violation, issued administrative citations, etc., and those still have not resulted in a violation being cured, then criminal prosecution may be an option for the city. Well, actually, any litigation is an option for the city, either criminal or civil at that point. Criminal or civil litigation could also be considered where we know the administrative remedies would be ineffective. For example, there is a situation where the property owner lacks mental capacity or the ability to cure the violation. So if the city were to pursue administrative remedies, it would be futile. So filing a litigation matter is an opportunity for the city. With regards to criminal prosecution, however, because it is typically happens much faster than civil litigation, this may be ideal over civil litigation in order to save time and to get a quicker result for the community. Now, if there are serious violations that require immediate action, obviously the city might want to look at something like criminal prosecution because it does move much quicker, or an abatement warrant, for example, just due to the time issue. Now, on to the next one. Now, the advantages of criminal prosecution. One of the biggest advantages of criminal prosecution is really the deterrent effect that criminal courts and the process has on our potential defendants. Because these defendants have the possibility of a misdemeanor on their record, including a conviction, jail time, and probation, that's likely to have a huge, it's going to be a huge incentive to deter property owners or business owners from continuing to violate the code and to correct violations on the property. With a misdemeanor on someone's record, this could affect the defendant's licenses, such as a business license or licenses that are issued through the state for contractors and what have you. It can also affect a defendant's immigration status, which may prove to be great leverage should you need it in order to resolve a case. Further, the fact that these cases, if resolved with a conviction or a guilty plea, can include probation up to 3 years. And if you can get the defendant on probation, this keeps the property owner or the business owner within the court's jurisdiction during those 3 years, which helps you maintain a property or business in compliance during those terms of probation. Now, one of the things that may also be advantageous is that there is a certain stigma that would be applied to repeat offenders as the record builds, as they are convicted or pleading guilty to repeated misdemeanors. Their record necessarily is tarnished, and especially if they're in front of the same judge and the judge is seeing the same offender repeatedly, it certainly helps in getting a stronger response from your bench officer in an effort to deter future activity. Now, one of the great things about code enforcement prosecution is that the case law says for building and health and safety code enforcement cases, these are strict liability cases. That means for a city prosecutor, you need not prove mens rea. All you have to establish is that the code says one thing, and that the conduct or the condition of the property or the business is in violation of the code. That is all. And under the case law, you should be able to get a conviction whether you're in front of a judge or a jury. Also, as stated earlier, generally, criminal courts move quicker than civil courts. They're also less costly in part due to there's less paperwork. In civil litigation proceedings, there's typically a lot more pleadings that need to be filed in terms of declarations and what have you, and the motion process is a little more tedious when it comes to paper. Criminal courts sort of fly a little fast and loose when it comes to that process, and as a result can reduce costs. Next slide.
Actually, Christy, can I just a couple questions real quick? How long, with a criminal prosecution conviction, how long do they typically stay on someone's record?
They will be forever, whether you use it as whether you're capable of using it to your advantage. Let's say if that particular person were to testify later, does have a time period, but somebody's criminal record, unless you get it expunged or somehow are able to get it removed, it will stay on there forever.
And then also, can you give a sense of, you say shorter period of time, what's the typical amount of time from filing to trial, and also how much control does the property owner defendant have to delay?
Well, that is definitely going to be specific to whatever county you're in, the court you're in, and the judge you're in front of. So in some counties, they will allow cases to remain open for an extended period of time before putting any pressure on the parties to resolve the issue or to set it for trial. In some cases, they don't like having matters on their docket for an extended period of time, and it'll definitely move quicker. Now, certainly, the defendant is got control over the timing to the extent that under the Constitution, the defendant is entitled to a speedy jury trial. So if he's out of custody, he's entitled to a trial within 45 days. If you want to enter into an arrangement where you're establishing a timeline for compliance, the defendant needs to waive time, which is what we say in court, to allow them to set a court date after the 45 days. Now, the defendant does not have to waive time. They can refuse to waive time and require that the local entity go to trial within that 45 days.
Okay. All right. Now, Charlene, you're now going to share with us some of what you think the disadvantages are of criminal prosecution.
Absolutely. Good afternoon, everybody. Thank you for joining us. I think when we're talking about our toolbox of code enforcement remedies, the administrative remedies generally tend to be less costly than either the criminal or the civil litigation. With regard to criminal cases, while generally they're a little bit more cost-effective than civil cases because, as Christy mentioned, there's less paperwork and less briefing up front. Discovery is also more limited in a criminal proceeding. Criminal cases are cost less than civil cases, but in general, when we compare it to administrative remedies, they still can be costly, particularly when you're talking about a misdemeanor charge. This is because the defendant has the right to a public defender and a jury trial. We'll go through it later when we go through the criminal process, but it takes significant resources to prepare for a jury trial if that's what we're looking at. We have to prepare our witnesses, and oftentimes, depending on which city departments are involved, we're having to prep the witnesses, prepare our evidence, which usually consists of exhibits and plans, etc. Those types of things in a criminal code enforcement case are they're more voluminous. The exhibits and the testimony are much more than you would expect, for example, than a DUI case. So that's one disadvantage, is that if you're going to trial, the cost can go up significantly. With that being said, in my experience, most criminal cases do not go to trial because the overarching theme in code enforcement generally is compliance. So once there is efforts towards compliance and/or compliance, we try as much as possible to resolve the cases to obviate the necessity of a trial, and we'll go over those at a later in our presentation. Another disadvantage of criminal cases is the perception of the city prosecuting its citizens. And this is going to be very unique to your particular city and your community. There are some cities that don't want to prosecute quote-unquote criminals. And I've heard it many times. You go in court and maybe there's a property owner who is an absentee property owner. Admin sites and other administrative remedies have not been successful. So what we do is we file a criminal action to get the attention of the property owner. They hire private counsel and they insist that their clients aren't criminals. And usually that's enough of a deterrent effect in order to obtain compliance. But there are many cities that don't want to appear to be prosecuting its citizens. Another disadvantage is the possible negative judicial attitude towards code cases. In the arena of criminal law, you have infractions, which are equivalent to like a parking ticket. You have, infractions, misdemeanors, which are, for example, like DUIs and these code cases, generally speaking, and then you have felonies. All DAs and public defenders start off at the misdemeanor level. So when they see our misdemeanors coming in, they don't technically like to take it seriously because they consider their felony matters more important. And sometimes that perspective, depending on the judge, will affect them as well. The court systems, as many people know, are heavy. We have sometimes in certain courtrooms we have 120 cases that we need to dispose of in one day or deal with in one day, and the perspective is this is not a criminal matter. You need to utilize other remedies, and so that's something we have to keep in mind. Many times, though, we're successful in communicating to establishing a presence in certain courtrooms and communicating with those judicial officers about code enforcement in general and why they're in place. And that's essentially, again, compliance, communities, and it's a little bit different than the garden variety criminal cases. Another disadvantage of criminal cases is a higher burden of proof. And this is something, as opposed to civil, and this is something that you want to review at the outset of considering any case. When you know that there's a case where you have not obtained voluntary compliance, administrative remedies have not been successful, you want to resort to litigation, one consideration is in determining whether to go criminal or civil. In criminal, we need to prove the violation beyond a reasonable doubt. And so we need to ensure, and we'll talk about this later, that all of our evidence is ready at the initiation of the action, whereas we'll talk about it later as well, that for civil cases, it's a preponderance of the evidence, it's a lower evidentiary burden, and also most of the time they don't include jury trials, so we'll talk about that as well later.
And Charlene, before we go to the next slide, a couple questions. How frequent do the defendants actually invoke either their right to a jury trial or their right to a public defender? Is that par for the course, or is that a rarity?
No, it's not rare. It's one of the biggest tools that they have to compel us to, for example, reduce our offer. Because there is going to be a perspective of why are we going to pull a jury for this misdemeanor and expend public resources on this case when I have a murder case coming up. And so that won't sit well with some courtrooms. So it's a great tool for them to have. They typically elect the jury trial. They don't often waive it. And if they are entitled to a public defender, they almost certainly will be appointed a public defender.
And
so
in terms of, go ahead.
I would say 90% of the time.
Okay. And in terms of judicial attitudes, does that tend to be a judge-by-judge thing, or is it even a county-wide? If there's a negative attitude, does that tend to be on a county-wide basis, or is it a judge-by-judge sort of thing?
I think it's a judge-by-judge thing. The one other disadvantage that I do want to bring up as we're talking about our toolbox of different remedies is criminal cases are great for punishment and deterrence, but when you want the actual, if there is a violation that needs to be corrected, we can obtain orders from the court to correct a violation on property in a criminal case, but if the defendant doesn't do it, the only thing the court can do is fine them, give them jail time. It's not a direct remedy to correct the violation, and that's a disadvantage. And in those, under those circumstances, you'd probably want to go, the abatement warrant route and/or the receivership route. And right. We've discussed the administrative remedies before, and we'll discuss the receiverships next week. But that is one, in my opinion, a big disadvantage in criminal cases. But I think Christy alluded to that earlier when she said that, when it's an unlawful condition, the criminal remedy might not be, as appropriate as the other remedies we have.
So to clarify that, Charlene, essentially, under no circumstances can a criminal prosecution result in the city either getting a receiver appointed over the property or the defendant property owner losing title to their property. You basically have to go outside the criminal court if that's the goal, correct?
Correct. There's no direct authority on point that doesn't say a criminal judge can't, under the Health and Safety Code, appoint a receiver, assuming the defendant, violated his probation or what have you. There isn't necessarily direct authority on that, but I think it's been tried before, and I don't think any criminal judge would appoint a receiver following a criminal case.
A city should assume that that's not going to be the end result of the criminal prosecution then, right?
Correctly, yeah, correct.
Okay. All right. So on to the next slide, correct?
Yes.
And Chris, you're going to talk, why don't you share with us your thoughts on how criminal and civil code enforcement actions differ?
Thanks, Mark. One of the key differences between criminal and civil litigation is if this plays out to the final end, the decision body, the decision maker, can be either a judge, as it would be in civil court, unless, of course, like Charlene mentioned, the defendant's willing to waive a jury, but it's very unlikely. It's more likely that you'll be in front of a jury in a criminal setting. Now, this is a significant consideration, especially if you have a case where the defendant is going to be sympathetic to the jury. For example, the property owner or the business owner is elderly or has a large family, family obligations, for example. Any facts like that that may make your defendant sympathetic to a layperson would make for a huge consideration. That's also true if you have any facts that you can anticipate that could sway a jury. A bench officer is going to be more likely to follow the case law than to be easily swayed by factual issues throughout the case. So in the civil setting, since there is no jury or no right to a jury, that is one of the big considerations when you're looking at this. Now, in both cases, you will argue underlying policy issues. Now, by that I mean if you're dealing with, say, an unpermitted structure, you would argue that the reason we have to move forward is because unpermitted structures, or excuse me, the building code was put into place to prevent unpermitted structures, since unpermitted structures are more likely to collapse and injure someone, or unpermitted electrical is more likely to catch fire, for example. And that's why this not only has an impact to the resident himself or the property owner himself, but to the entire community. Because if one structure catches on fire, it could catch the entire neighborhood on fire. Now, in both cases, you would be arguing policy as to both. And you want to consider that in light of your facts and your defendant when deciding whether to go with criminal or civil. Now, another really big consideration is civil cases will have a stronger set of statutes or codes that allow for the local entity to recover attorney's fees. The government code has a provision for recovering attorney's fees. There's several health and safety codes that have provisions for recovering attorney's fees. As I'm sure you'll discuss tomorrow when discussing receiverships. You want to also check your municipal code. It's likely your municipal code has a provision that the city, if it's a prevailing party or any prevailing party in any action the city initiates, entitles that prevailing party to the recovery of attorney fees. If that provision is not in your municipal code, I'd highly recommend adopting some language in your code to address that, so that if you ever do seek attorney's fees, it's made very clear in your code that you're entitled to those fees. Now, when you compare against civil and criminal, there are some civil remedies that may be more appropriate than criminal action. For example, the civil courts have the ability to issue a temporary restraining order or a preliminary injunction quickly. Those allow the city to deal with some immediate concerns that they have with regards to public health and safety, and it allows you to stop conduct much more quickly. If you have a condition, for example, that's a threat to an immediate threat to public health and safety, it would probably be more appropriate, or could be more appropriate, depending on your situation, to seek an abatement warrant. The abatement warrant would allow the city to go on the property for the purposes of curing a violation. The one thing about that, these abatement warrants are sort of quasi-civil, quasi-criminal. You'll notice as you go through that process, when you're seeking an abatement warrant, some courts will send you to a criminal judge. I think in part because they see the word warrant, and some courts will send you to a civil judge for execution, and I think that's in part because abatement warrants are governed by the California Code of Civil Procedure. If you do go the abatement warrant way, check your code. You may be required to hold a public nuisance hearing in advance of seeking an abatement warrant. That's very code dependent. Now, like Charlene was saying, this is where the disadvantage of criminal comes in, is the court can't order the property owner to, remedy the situation. That's more something you deal with as a term of probation, and we'll get to that in a little bit. Now, next, one of the civil remedies that may be more appropriate than a criminal action is when you have a defendant who's basically incapable or unable to take action to remedy a violation on his property, or continue to remedy maintain his property in a certain state. One of these reasons could be mental capacity. They're elderly. They may have addiction problems. They could suffer a mental disorder, such as a hoarder, for example. And in those cases, it's likely more appropriate that you would seek a receivership or a civil action. I know tomorrow you'll be talking about that. One of the advantages there as well is cost recovery. So these are all considerations we want to we want to address before we decide which path we're going to initiate, whether it's criminal or whether it's civil, and which one is most likely to be successful or unsuccessful, more likely to result in a recovery of attorney's fees, or one that will move quicker than the other. And all of that is very factually driven. And that's it, Mark.
Okay. Before we go on to the overview of the criminal case, I did want to make one clarification, and that's that there is the civil receivership action, and then, Christy, you talked about the TRO and preliminary injunction action that you can seek in civil court. It's important to note that even in the TRO preliminary injunction case, you can get, unlike with the criminal prosecution, if you get a judgment for an injunction and there's failure to comply, that is also a separate basis for the receivership remedy. So in civil court, you can either do a direct receivership action if you meet the requirements for health and safety code receivership, or if it's a situation that doesn't justify a health and safety code receivership, you may still be able to get to receivership if you initially get an injunction and there's not compliance by the property owner. So receivership is a remedy for the failure to comply. By comparison to a criminal case, receivership is a remedy a court is available if there's a civil injunction that the property owner doesn't comply with. Okay, so let's move on and talk about the actual criminal case. And Christy, you're going to begin and talk about the investigation.
Okay, thanks, Mark. Now, it's really important that you understand, what evidentiary needs the prosecutor is going to have, as you move forward with your criminal case. One of the reasons for that is because the criminal case isn't usually initiated until we have almost all the evidence, or if not all the evidence, we need to essentially win at trial. And that's not just to win at trial, but it's to leverage, hopefully, a easier resolution to this case. Now, the reason that you need to make sure your evidence is built up so strongly before initiating the case is because you don't have very many discovery tools like you would in a civil matter. And in the criminal case, once you initiate your case, it's likely that you're going to have a difficult time getting evidence from your property owner since you're now in an adversarial setting. So let's talk about some of the evidentiary issues, warrant issues that we see as we go forward, as we conduct our investigation and collect evidence for the purposes of our cases. One of the main issues has to do with plain view, and this is basically means that you don't need a warrant for anything that is in plain view. If you can observe a violation from a public spot or someplace in which there is no expectation of privacy, you can photograph that violation, you can record that violation, and you need not a warrant or consent. You can go into an open field, for example, and collect evidence because that has no expectation of privacy. And the case law says that the local entities are entitled to go onto an open field for the purposes of gathering evidence. Now, at what point would you need a warrant to go onto private property? Well, the way I like to make it sound easy is to tell the officers that they can go anywhere Brown goes. And by that I mean that the officer can enter any portion of the property that a mail carrier or UPS or FedEx would go to deliver a package. So if you have a front door that is unobstructed, no locked fence or what have you, then the officer can enter the front yard for the purposes of photographing evidence, posting notices, or any other investigation that needs to be done from that area, because there is no expectation of privacy in that area. If, however, there is a fence that blocks entry into that front yard area, and that fence is locked, and it's clear that there is no intent to allow people to enter that portion of the property, just like UPS would not be allowed to enter that portion of the property, then the code enforcement officer cannot go to that portion of the property. So what do you need to enter private property? Well, there's two. One is consent, and the other is an inspection warrant. The case law says that under the Code of Civil Procedures that govern abatement warrants, you can also seek an inspection warrant, or vice versa, and in order to enter private property. One of the things that, like I mentioned before, it may be the case, it may not be the case, depending on what you're seeking. There may be some hearing requirements under your code, but if you're simply seeking an inspection warrant, it's likely not a requirement. You would need the property owner to deny you consent to entering the property, because the statute requires that your declarant, which is likely going to be your code officer, be able to declare that they've requested entry to enter the property, but have been denied. If it's another issue where you can't request, for example, entry because there is a vacant property or absentee landlord, and you've attempted to make contact with the property owner and been unsuccessful, if you can show that requesting entry would somehow be futile, you've likely met your statutory obligation there and should be able to obtain an inspection warrant for entering private property for the purposes of observing violations. Now, if you do get an inspection warrant, you do want to keep in mind that you should be filing a return to warrant with the court. That is, after you've conducted the inspection, you would submit to the court a pleading which identifies all of the observations that were made at the property, including all the violations that were observed. Now, if you have consent, that's great. You don't need a warrant to enter the property. But one thing to keep in mind is making sure that you receive consent from that person who has right of entry to the property. So this goes to a sort of landlord-tenant issue. If you ask the landlord for right of entry, the landlord is obligated to follow the provisions of the lease agreement. So if the lease agreement says the landlord is not allowed to enter the property without giving 48 hours notice, then the landlord has to give 48 hours notice before he can grant you right of entry to enter the property. The tenant automatically has right of entry to the property and can obviously consent immediately to the city entering the property for the purposes of observing violations. So just make sure that whoever is consenting does have the right of entry to the property. Now, when you're entering property, we want to take a lot of photos while you're there. You may not get the ability to enter the property again for the purposes of taking photographs as things get a little more controversial, adversarial. So you want to make sure you're taking lots of photos while you have the ability to be on the property. I would strongly recommend that when you're taking these photographs that you use the date stamp on your camera. This will be crucial for some cases where you're showing a pattern of dilapidation of a structure. For example, if it's a slumlord and over a period of a year the property goes from minor dilapidation to severe dilapidation, all these photographs will be useful for you to leverage a resolution or at trial as exhibits. And having the date stamp allows the officer who took those photographs to testify easily as to the timing on those photographs. It also makes it very easy to follow should you be in front of a judge who's looking at this with regards to motions or jury's been waived. Now, one of the key things to think about when you're looking at the evidence in your case file as a prosecutor are the logs that are kept by code enforcement officers. Oftentimes, cities have computer systems or handwritten logs where they track all of their site inspections or correspondence with the property owner or business owner, and they track what their observations were. It's important that these logs, when you train your staff, that we remind our officers or whoever is keeping the log that those entries need to be objective observations or just a reiteration of statements that were made, and not, for example, the officer's opinions about the property owner. There can be some difficulty in terms of if this seems biased that's going to be a problem if it appears that the code enforcement officer has made some commentary or judgments about the property owner or business owner in the log. That log will be handed over to the to the defendant or defense counsel, and so they have to be clean, if you will. They need to only represent factual observations. And that goes down to the prosecutor has an open file. What that means is that as a city prosecutor, I have to give to the defendant everything. They get everything except those things that we argue are attorney-client privilege. And in some cases, there will be motions where the defense counsel will file to get even attorney-client privileged documents. So that's why it says that we have an open file. They're entitled to all of our documentation, including unredacted logs, to the extent it doesn't include privileged material. There's also the issue of other city documentations of a violation, which may come from your planning department in terms of inconsistencies in the planning permits or building permits and the actual construction that was done, as well as many other departments that cross over along this line. And I think that's it for this slide.
Charlene, you're going to provide an overview of the initial filing and the initial hearings on the case. Please do that.
Yes. Yes. What's the case is before the city prosecutor, and he or she believes there's sufficient probable cause that a violation exists. That he or she will initiate a criminal complaint in the criminal court, or the criminal case can also be initiated by a citation issued by a code enforcement or peace officer. I have here that there's the difference between infraction and misdemeanor. I have here that the maximum penalty of an infraction is $250, and there's no jury trial, no public defender, and no imprisonment when you're charged with an infraction. This is under the penal code. On our slides, the difference between the infraction and misdemeanors under the penal code, you might want to check your ordinances because generally speaking, the penal code sections apply unless an ordinance is adopted setting forth a different, for example, different penalty amounts. I won't cover it in detail here, but the reason why at the end we'll talk about making sure your codes are updated is because there are different mechanisms that we can use in terms of utilizing the criminal process. For example, some muni codes have a discretionary penalty provision, also known as a wobbler. Under the government code, violations of municipal codes are misdemeanors unless they're deemed an infraction by an ordinance. Many cities adopt an ordinance that states, well, it's all muni code violations are misdemeanors unless the city prosecutor determines that it's an infraction. And that way, what we usually do is we file as we have the discretion to file either as a misdemeanor or infraction, depending on the severity of the violation. And then some ordinances also adopt a sliding scale. So, for example, the first violation is a $100 fine. The next violation is the next misdemeanor violation is a $200 fine, etc. Those are the general penalties for infractions and misdemeanors. Once you file that, the first appearance is an arraignment. This is where the defendant will be advised of their constitutional rights. They'll plead guilty or not guilty or no contest at the time. If they plead not guilty, they have the opportunity to be appointed the public defender at that time. It also starts the time in which we're required to bring the defendant to trial. As Christy mentioned earlier, when the defendant is in custody, their right to speedy trial requires that we bring the trial within 30 days. When they're not in custody, we have 45 days from the date of arraignment. The next hearing after the arraignment, a pretrial hearing and or a trial readiness conference is set. This is an opportunity for the court to ensure that the discovery is provided. It's also usually the time, although it can happen at an arraignment, where the prosecutor gives an offer to the defendant and or his counsel. An offer is an offer to resolve the case. So, and it's essentially the starting negotiating point for which you're willing to resolve the case at that point in time. This is really important because it's an opportunity to fashion creative remedies. We've discussed that generally speaking, the remedies in criminal cases are fines, jail time, potential probation. But at this time period, there's also a time where we can be creative. For example, we could do a civil compromise, and that's essentially an agreement between the defendant and the victim. In this case, it would be the city and the general public, and the city would enter the city would enter an agreement with the defendant where they agree, I'm going to abate, number one, abate the violation, number two, agree not to maintain violations, and number three, make the city whole again, which is the victim, and pay a certain amount of attorney's fees or a fine to the city. Once those conditions are met, the agreement is signed. At that point, the city can dismiss, or the prosecutor can dismiss the case as a civil compromise. And that way, there isn't a conviction. The defendant doesn't have to plead guilty. That's one of our biggest tools that we have, particularly when we have properties and our businesses with unlawful conditions and we want them abated. What we would do is we'd continue the pretrial, monitor the progress of the abatement, and once the abatement is complete, we try to tie it up with that final agreement, and then we could dismiss the case at that time. Another thing that I like to do is sometimes you have circumstances where it may not be appropriate for a criminal conviction for a particular defendant. It may be, maybe it was a 19-year-old who has, who's shooting a BB gun without a permit. And he wants, for example, he intends to enlist in the military, and he really can't have a criminal conviction. Or you may have an open container case, and one of the defendants really doesn't want to have anything in his record that alludes to alcohol. When a conviction is not appropriate, something I like to do is do some kind of informal probation, where I say, okay, well, since this is your first violation and it seems like you got your act together and you've acted and you've moved towards compliance, what I'll do is we'll continue the case for 6 months or 9 months or even a year if you have no more violations, and or if you prove that you surrendered the gun or surrendered the BB gun, and or maybe if you've taken 20 AA classes, I'll dismiss the case, and showed proof of that or showed proof of community service, I'll dismiss the cases in 9 months or a year. So that's something that I like to do because it allows us to appear to be reasonable in case this gets before a judge or even to the opposing counsel that, look, I'm not trying to deem your client a criminal. I'm trying to be reasonable here, and it allows us to create fashion very creative remedies that may not be possible in other enforcement mechanisms.
Okay, well, sometimes we're not able to resolve, and they do have to go to trial. So, Christy, why don't you tell us about that process of actually these cases going to trial?
Okay. Now, I won't spend as much time on this because, like Charlene said, jury trials in these kinds of cases don't happen all that often. But in the event we do end up in trial, the first thing that occurs is Wynder, which is jury selection. And this is where both the prosecutor and defense counsel select from a pool of people from the community. They select their jury. And this is a process where you ask questions in order to solicit bias for or against your position. One of the things that's key here is identifying for the jury what code enforcement is. I have been in front of many juries where there were several people in the pool that had no idea what code enforcement was. So I often rely on an HOA example, homeowners association example, since many people are familiar with CC&Rs and violations that result from that. Now, once you have your jury selected, you'll go through your pretrial motions and then start trial. Now, when you're in trial, there's various items you can use as exhibits to help sell the story. Now, obviously, photographs are going to be a very big deal and often are in code enforcement cases. There are things like zoning maps, plans, permits, and public records that we are allowed to get in either through business record exceptions from the hearsay or through a request for judicial notice. Keep in mind, reports do not come in. So if you have a report from, say, your environmental health department or the Alcohol and Beverage Commission or the police, those don't come in. You need the officer to come in and testify. So your witnesses would then include law enforcement, ABC officers, code enforcement officers, building inspectors, business license technicians, permit technicians, planners. You can even bring in neighbors to testify. But you have to remember that the defense gets an opportunity, it has a constitutional right to cross-examine witnesses that the prosecution puts up. In case of neighbor testimony, they often fear retaliation. Now, of course, the defense or defendant cannot threaten retaliation or retaliate against a neighbor for testifying. That's considered a felony. Nonetheless, it may be a disincentive, and your neighbors may not be willing to testify. Now, sentencing is really key to this process, and it's key whether or not you've entered into a plea agreement that's going to result in a guilty plea to a misdemeanor, or you've got a conviction on a misdemeanor. Now, the maximum that you would be able to request from a judge is 6 months in jail or a fine of up to $1,000 per violation. Now, that's important because in code enforcement cases, every day can be considered a separate violation. So you can file multiple misdemeanors against a property owner or business owner for an ongoing violation, which allows that $1,000 to multiply times the times you got a guilty plea or conviction. Now, what's really, really key to this process, though, is probation, especially if you're dealing with the maintenance of a violation. You can ask that the defendant or business owner or property owner be put on 3-year summary probation, like Charlene was saying, require them to abate the violation or require them to maintain the property in a certain condition so as to not allow the continued violation of something. Now, what's important here and to make sure that your defendant complies with his terms of probation is by asking the court stay certain terms. And what that means is that those terms of probation are not imposed against the defendant until the defendant violates probation. So if the property falls back into a state of disrepair, for example, you can bring the defendant back into court and ask that the court now impose one of the state terms, which could, for example, be fines payable to the city or the court. It can be community service or jail time. These hanging over a defendant's head are really important to ensure that they comply with their terms of probation. On to the next slide, please.
Okay, let's talk a little bit about best practices.
Okay, so really what's key into succeeding in a criminal code enforcement case is the language of your municipal code. So you want to make sure that you review your municipal code to ensure that you've got, the criminal prosecution portion of your code is updated to ensure it's a misdemeanor, for example, that your fine amounts are up to date under statute, and that the language is clear, that a jury would understand that the property owner or business owner was on notice, that it was clearly a violation of the code. Some of the key portions of your code that you want to address are the public nuisance provisions, your property maintenance provisions, noise provisions. Not a bad idea to review your sign codes, since those often come up. But any of the portions of the code that you see a regular violation of I would recommend you send those to your city attorney's office for a review to make sure those are as clean as possible, because that will become very crucial during a criminal code enforcement case. Next, it's also a good idea to have a code enforcement manual. The manual can have all the practices and protocol for each and every remedy that the city uses for enforcement, whether it's administrative, civil, or criminal. Being able to identify all the practices also helps your officers testify and our property owners be assured that the city or the code enforcement officer is following the practices that are in place and not, for example, targeting a particular property owner as a result of a protected class. Or, excuse me, like, for example, we get a lot of people claim that they are being targeted as a result of their nationality. If you can have your officer testify that he's following the practices that exist in the manual, that puts the city in a great situation. And with that, I'll turn it over to Charlene.
And this goes along with the manual, developing manual. It's ensuring that you develop policies, protocols, and procedures on what violations are appropriate to prosecute as infractions or misdemeanors. Obviously, you're going to, depending on the city and what resources you have available to you, internally, you need your respective departments needs to make a determination of what do we want to utilize administrative remedies for, the criminal remedy. What do we, if criminal, then what violations do we want to prosecute as infractions or misdemeanors? What assistance do we have? Can we have code enforcement officer? Do we have code enforcement personnel? To what extent can our police department or the sheriff's department can assist in these criminal cases? And to what extent do we have the ability to assist counsel or have counsel assistance for those cases? Additionally, ensure that your enforcement staff can adequately document the investigation and the evidence. I think Christy went through that thoroughly when we talked about the investigation phase of a criminal case. So I won't beat a dead horse there. And then again, ensuring all evidence is compiled before initiating the action. This includes relevant files from all participating city departments. Many times we have, as a city prosecutor, we'll get the code enforcement file, but if it's depending on the violation, we may need files from also planning. We may need files from the business license department. We may also need files from, public works, because there may be other violations that we could prosecute and/or additional evidence that we can consider and provide in discovery. So I think that's an important thing to keep in mind, that when you submit your cases over to the city prosecutor for review, that you ensure that any department that has touched this file in any way whatsoever also makes copies of those files for review. I think I'm done with that.
Okay. Well, Christy and Charlene, thank you so much for that presentation. Those of you who sent us questions, we will be assigning those questions to either Christy or Charlene, and they will be contacting you. Similarly, if others have questions, please email them to us, and there will be an email address provided you can send your questions to. And please join us next week, Thursday, February 2nd, which will actually be a 2-hour session because there's much to cover in the category, the section of the toolbox, civil remedies. We'll be talking about health and safety code receiverships, about unfair competition actions, abatement warrants, and a few other things. So please join us next Thursday at noon for part 3. And thank you, and have a great